At Barton Law, we're always happy to speak with you or your clients before you write your application. And I think it's particularly important in divorce or separation cases. The natural tendency when you're with customers, I'm sure I would do the same myself, is you're seeing your client, he then explains or she explains that separated or going through a divorce. The tendency in that time is in your mind to think, goodness, well, a divorce will take 18 months, 2 years, maybe 3 years, and you're mentally closing your briefcase and exiting the meeting. What I'd always say is, if the information you're given before the meeting suggests that might be the situation, please do make contact with us, because in this situation, there are two scenarios and two possible solutions for a customer. If your clients are already in the middle of a divorce, then in order to get to completion of that case, there are three things that we need. We first of all need to see a decree absolute, so not the nisi. If they have the nisi, we know we've got a 6-week time period from lodging of the absolute. All the lenders will want that, all the lenders' solicitors rather. They'll also need to see a court-signed financial consent order. Within that financial consent order, there can be no ongoing maintenance obligations to the departing spouse. Thirdly, and lastly, if the departing spouse or exiting spouse is on the deeds, there'll need to be a transfer, which has to be signed and prepared prior to completion, which we'll hold until the day of completion. So those two things are crucial if the clients have already started the divorce proceedings. If you get there, they've already got nisi, they've instructed solicitors, that is the only route you can take, and they'll be able to give you a better idea of how far down the line they're on that. If you get to the meeting and they're very recently separated, then clients do not have to proceed with the divorce proceedings. As we all know, divorce can take several years. There is what I would always term the sticking plaster solution, which is the separation agreement, which is quite simply the exiting spouse signs an agreement. They would obviously need to take independent legal advice. They would sign a separation agreement whereby they relinquish all of their claims on the matrimonial property. Both parties would have advice. We can assist with certainly the person taking out the lifetime mortgage, but certainly timing-wise, a separation agreement, if it is amicable, and everyone always says, unfortunately and sadly, that it's amicable. If it is amicable, timing-wise can be done in the normal life, even with a short offer of 6 weeks. Financial cost-wise, it'll be an additional £1,200 to £1,500 to resolve that. But there's no reason the route of the separation agreement why can't it be done in the life of the first offer if both parties are happy to proceed in that way. The only other thing we're seeing really our clients are actually borrowing money to help with their children's divorces, which is quite sad at the moment. But on that one, interestingly, our customers are waiting until the clients until their children have submitted the decree absolute, because you don't submit the decree absolute until the financial consent order has been agreed. So that's the only other thing that we're really seeing. But I think it's also really a call to the advisors is, whilst we're not out asking the advisors to do our job for them, I think it is important to stress that we can't do anything here. We wouldn't even get an offer signed really until we knew the financial consent order was with the judge and until the decree absolute had been applied for, because obviously if the decree absolute's going to take 6 weeks, then that is the life of an offer. So the typical offer is 42 days. So if we had an offer signed up and then the lodged consent order, that will have expired. So it's very much, for customers who want to do this quickly, it is very much, we would have to push back to them and say, these are the timings. You need to keep us informed of that.